Welcome to Legal Research the Old-Fashioned Way, a strategy for efficient and effective legal research. I am Leslie Ashbrook, a law librarian at the University of Virginia, and along with Ben Doherty, another research librarian at UVA, we're going to talk to you today about how to approach legal research out there in practice. For a forthcoming article in the Virginia Lawyer, Ben contacted a number of Virginia and Fourth Circuit appellate judges for advice on legal research. From the responses, some themes emerged. The majority of the judges emphasized the lack of time spent on analysis in the research and work they received from you, attorneys. So that's the biggest thing we want you to take away from today's presentation, is you've got to give yourself enough time in your research and writing process to perform analysis. We took the rest of the responses and we've divided them into 4 themes from the judges that today's presentation will focus on. The first is preserve credibility by slowing down your research and understanding the big picture. We will then move on to spending less time online searching and more time analyzing your findings. This is getting to that big theme picked up on by the judges. We'll then move on to taking advantage of secondary sources. And we'll finish up today's presentation talking about how to use tools, including online databases, for their strengths, not just because they're there. Preserving your credibility by slowing down and understanding the big picture. It is not enough when you're doing research to recognize just your specific point of reference. You've got to know how it fits into a bigger corpus of work. Work product is rarely judged by how many cases you find in a given period of time. Instead, work product is assessed by how well it addresses the client's issues, the partner's demands, or the court's requests. Before you start researching, spend time thinking about the actual end goal of your research. This time spent at the beginning of the research process, getting your mind around what you're actually going to do, is more than made up for later on in the process when you're not struggling to create a path. So what are you actually trying to do? What's your end goal in this research? What is the final product? Is it persuasive? Is it informative? Who is your audience? Use that brainstorming time to think about the sources that would best help you achieve your research goal. If, for example, your goal is to get up to speed in an unfamiliar area of law, you might be better off looking for a good treatise instead of automatically going to Lexis or Westlaw and starting to run searches. It is also in this brainstorming session that you give yourself a chance to wrap your head around the legal issue you are wrangling with. We all work under time pressures. We are not suggesting that you take hours to mull over the possible research avenues. We are suggesting that you pause before jumping into research to think about what you are even trying to achieve. The time you take at the beginning of your search to set up your search correctly will save you time down the road.
Once you've followed theme 1 and taken a little time to slow down and think about what you're doing, that'll lead you directly into our second theme, which is spending less time online searching and more time actually analyzing your findings. We think that once you take a chance to actually think about what you're doing, this will be obvious to you as you realize that you need to take a moment to step away from the searches and figure out what you have before you. So analysis was a big point from the judges. They wanted to see attorneys spend more time on analysis and less time simply doing online searches to find things. So what this means for you is to do your searches, but then step away from those online databases so you can actually carefully read what you have found, whether they're cases or statutes, regulations, other sources. Figure out what you have before you, how it all fits together, how your client's situation fits within this body of law you have analyzed, and what might be the most important factors from these cases or from the statutes that the judges will consider in rendering their decisions. In doing that analysis, the judges wanted us to remind you not to forget about the facts of the cases. This was very important to them, that cases are fact-driven. The decisions that the judges are making are fact-driven. Obviously, the legal analysis is important, but each case is driven by its particular facts. And the judges expressed a preference when you're doing an analysis of cases for them to use those cases in which the facts are most similar to your client's situation or whatever it is you are arguing about in the court. For example, the other day in advanced legal research class that we both teach at the University of Virginia, we did an in-class exercise in which we looked at cases from Maryland having to do with whether our imaginary client had sufficient intent to distribute some powder cocaine that he had been caught carrying. And what we discovered in class is that there were quite a few cases in Maryland, a lot of Maryland case law on this issue of how to determine whether somebody has sufficient intent to distribute. And so the focus at that point became looking at those cases in which the facts were most similar to our clients. So that was not the cases having to do with heroin, not the cases having to do with crack cocaine, but specifically those cases having to do with powder cocaine, because that is going to be most relevant to the judge's decision. You could get the legal analysis from any of those cases. Any of those drug cases are going to give you the basics on what the legal background is for determining intent to distribute. But most useful to the judge's decision is going to be how prior courts, how prior judges have decided cases involving similar facts. And so we discovered the best thing to look at in that particular instance were the powder cocaine cases. Those are the most relevant, even if the legal analysis was equally valid from any of those cases. So be sure to do that. Don't just take the first case you come across with a good legal analysis, but see if you can find those cases that are most factually relevant to what you are trying to establish before the court. When you're doing this analysis, when you're spending time with your resources, you'll realize that that means you cannot dwell too long on online databases. It's obviously very easy in Westlaw, Lexis, or any other database to do search after search, go from hyperlink to hyperlink, always looking for another good nugget of information. But in order to focus on analysis, you have to step away from that a bit. You can't spend all of your time searching and then at the last minute just plug those search results into your brief. Instead, you have to spend your time searching, but then give yourself time to step away from the databases so you can actually do your analysis. You'll find very likely if you're doing Virginia state practice, for example, there may not be a whole lot of cases on your topic. And so once you've found those cases, once you've used those online databases to find the relevant sources, step away from the constant searching that those databases promote and spend some time thinking about what you have found. At the same time, the judges pointed out that there are some online research traps that you want to avoid. For example, the judges pointed out that although keyword searching is a very powerful tool to use for legal research, there are perils of keyword searching. At the extreme, the judges said that they've seen examples where people have done great keyword searches, found great legal language or quotes to use from other cases, but did not realize that those quotes or that language was actually coming from a dissent, and so was not actually law. But we're coming from a dissent in the opinion. And you can see how this can be easy to do. In an online situation, you're looking just at that little box on your screen. If you're rushed, it can be very easy to not realize that this great language you found is actually not coming from the opinion in the case. The larger point, though, the less extreme point, is that you want to make sure to know context. So when you're doing your keyword searching, that's great if you find good legal language, you find a great quotation, but then make sure to look at the big picture. Going back to our original theme, theme one, look at the big picture. know your context, take a look at why that language is in place in a particular case, understand the case as a whole, because that's what's going to be important to the judges. Know your audience in all of this. When you're doing your keyword searching, realize that these cases are not just strings of words that you can then search through to find a good quote to pull out from here, some good language to pull out from there. These are real cases, and it's very likely if you're before the Virginia Supreme Court or the Virginia Court of Appeals that they're already aware of those cases. They may have even sat on this case, helped the decision. They may have written the opinion. They may know the person who did. They may know the backgrounds to why that particular language is in the case. So you want to make sure that you understand that as well. You understand what really drove them to write this language, to include it in their opinion, not just pull that good quote, but understand the full context that made them produce that quote in the first place. The judges pointed out, too, that there are perils with cutting and pasting as well. So that's a great tool to use. Obviously, it's great that you can do some searching online in Westlaw or Lexis. You get some great language, very easy to cut and paste it into your brief or whatever document you're producing for court. There are traps with this as well. Again, at the extreme level, the judges said that they'd seen examples where somebody cut and paste language from some other document, had forgotten to change party names, had forgotten to change the formatting so it fit the rest of their brief. Those kinds of mistakes are easy to do, again, when you're in a rush and when you see cutting and pasting as too easy. But again, the larger point is this, is that briefs are not just cut and paste projects. They're not just arts and crafts projects where you're taking 5 different good quotes, pasting them all together in your brief, and then you're done. Again, you want to take the time for actual analysis. Cutting and pasting is great. It's a time saver. It's great to be able to take something from one document and easily put it into another document, but make sure you're doing the work behind that. Make sure you're doing the analysis behind that. If you are cutting and pasting, you're making sure what you're doing is correct, and you're setting it in the appropriate context. Next, because focusing on analysis gives you more time to spend just with your what your findings are, your research findings, this allows more use of free resources. So if your focus is on the sources themselves and looking at the language of cases or the language of statutes, it doesn't matter so much where you are getting them from. So Westlaw and Lexis can provide them for you. There are plenty of other databases as well. You can get them from the books. If you are spending more research time on actually analyzing those sources, you don't necessarily have to pull that language, those sources, those cases or statutes from Westlaw or Lexis. If you know what you are looking for, if you're dealing with a limited set of cases, as you often might be in state legal research, you can pull them from a place that's free or less expensive, and we'll go through a few of these in just a minute. And so that's one nice thing of a focus on analysis, is it allows you to kind of get away from the expensive Westlaw and Lexis databases and use free resources, which are providing you the same legal language that you would get elsewhere.
We started today's discussion by suggesting you slow down your research to think about the big picture and how your issue fits into the bigger scheme. This led us to tell you to take more time with your research analysis. You want to give yourself the best opportunity to show off your knowledge. We've been telling you to slow down, and now we're going to focus on telling you how you can actually make up that time using books. Or if you are using online resources, researching like you are in a book. And this is especially important maybe with secondary sources. A good treatise may give you most of what you need in an area of law without you ever signing on to a database. Spending a little bit of time thinking about your research goals before you start researching online gives you an opportunity to remember that there's a library, and that there are really great resources in there that aren't necessarily online. Finding the treatise that addresses your topic could be the windfall of your research project. And it also, I guess it doesn't really matter if the resource is online or in print if you approach the research strategically. So if you decide to use an online rather than a print source, the key is to think about how you're going to approach that research. If you're using the resource in print, it forces you to do this. There are only so many ways you can access information in a book. You are forced to look at things like table of contents and an index. It's unlikely that you're just going to flip open the page of a book to the right page for you. But that's exactly what you're trying to do when you're keyword searching online in a treatise. It's a little more guided than that, obviously, but if you slow down and think about how you could approach that research project as though you were using a textual hard copy book, you might have some surprising results. Again, most books come with something like a table of contents and usually an index. This allows you to knock out a great portion of what our first 2 points were pointing you towards. The index and the table of content can be time-saving because they point you to relevant sections without you having to get lucky with keyword searching. If you did your thinking at the beginning, you are now hopefully in a source that has useful information to your topic. You are searching it and browsing it to find the relevant info, and you are looking at how your information fits into the scheme of the resource, thus providing you a nice overview of the topic area. It's much easier in a book to browse the materials around your topic to see what else is there and how your issue fits in to the big picture. Make sure you take that step if you use an online treatise. If the source is good, it is pointing you to relevant primary sources and providing with a starting point for your analysis. So by taking a little bit of time to think about your issue and giving yourself the opportunity to think about what sources might be best for you to get started with your research, you have given yourself a chance to remember secondary sources. Using secondary sources wisely has allowed you to get started with understanding your issue in context and to find primary sources, which is giving you the time to spend actually analyzing these sources. Again, getting back to the main point that the judges made, that they want you to spend more time on analysis. When thinking about your research goals, think about if there is a source that addresses what your concerns are. There are a number of Virginia-specific and topic-specific practice treatises out there that might be useful. I just want to point out a few. West publishes the Virginia Practice Series, which covers a variety of topics in Virginia law. It's pretty practitioner-oriented and can be quite handy. There are a number of topic-specific treatises on complex topics of law. Lexis will publish some of these. West publishes some of these. Things like civil procedure, criminal procedure, evidence. The Virginia CLE also publishes a series of Virginia Lawyers' Practice Handbooks, which provide a lot of helpful background information on a variety of areas of law. These can be really great for a practitioner who's just been thrown a case in a subject area not super familiar to the lawyer. Related to using secondary sources for research is using secondary sources to stay on top of research. You cannot constantly be doing retroactive research, and I would imagine that many of you are reaching a place in your practice where you're not doing much backward-looking research. You're using sources to stay on top of the practice area in which you work. Since much of legal research is done in advance by becoming versed in your area of law, it becomes a lot simpler to keep up with new cases, laws, and regulations as they emerge. Taking advantage of newsletters, alerts, practice-specific resources, things generated by your firm or by bar groups to help you keep informed and up to date on your practice area is critical. I also just want to mention that there are some sources that are often easier to use in print than they are online. Large treatise sets can be one of those, but I think annotated codes are also an example of a source that can be much easier to use in print. For a number of reasons. One, it's easy to get into what Ben mentioned as that keyword search tunnel if you're online code searching, because you need to know where that word is showing up in context. And when you're using the print versions, you know exactly where your relevant statute is in the bigger context. It's also easier to look at multiple sections at a time in print. You can have them kind of spread out around you without flipping back and forth between screens. when you go online to search a code, think about how you would approach it if you were doing it in print. So we've been telling you to slow down and think about your research. We've suggested that the most important part of your research is the analysis. Then, while telling you to slow down and analyze more, we have the audacity to say use the books, or at least to search like you were using the books. When we are sure you are thinking to yourselves, of course you want us to use the books. You're librarians. You probably don't even use the computer. You're probably terrified of the computer. And honestly, we think that secondary sources, which are often in print, and things like annotated code in print, save you time by helping you do the better research for finding your sources. They help you see the big picture, and they help with your analysis. It doesn't mean that we think you should never use online databases. We think the most important thing to take away from this part of the presentation is that you have to use tools, including online databases, for their strengths. With that in mind, we're going to take a look at a few different resources online and talk about when we suggest going to them, some of their strengths and weaknesses. The first two that I'm going to talk about are Fastcase and Google. Fastcase is free to you as a member of the Virginia Bar, and Google is a free resource. So both of these can be great places to get started in research if you know what's available on them and it fits your needs. Using Fastcase for initial case or statutory research can be a really great idea. Fastcase works well when just fishing for cases through a basic keyword search or looking at a case when you already have a citation. So you kind of already have an idea of what you're pulling. You've got that citation. Just pull up the case in Fastcase. You don't need to spend any money doing that. It's also good if you don't really have any idea of what you're doing and you're just going to play around for a while and all you want to do is keyword search, which we don't think is always the best strategy, but if you're going to do it in a source that kind of meets those needs without racking up any type of bills. Fastcase lets you do that. Fastcase also lets you use a more precise Boolean searching. So if you're a savvy researcher who knows how to toss around multiple search techniques, Fastcase lets you do that. So if you're looking for cases or statutes and you want to use complex search strings, you could do that in Fastcase. For example, what I have up on the slide is modify /5 child support with child support in quotation marks. This is a proximity search combined with a phrase search. So this search is saying, I'm looking for modify within 5 words of child support. This is a type of search that looks familiar to you because you use them all the time, or it doesn't look familiar to you, but you want to learn how to use them. Play around in Fastcase. It'll help you find cases and statutes using these more advanced search techniques. Fastcase also allows for easy browsing or searching through the current Virginia code. And it even includes computer-generated annotations to lead you to some relevant cases. So if you just want to take a peek at an online Virginia code, Fastcase has that available. So you could browse, and then if you pull up a statute in the code, I have one on the screen you can kind of take a peek at. I think this one deals with modifying child support. You can see that it has a list of annotations below it. So the kind of the same thing that you're getting with Lexis and Westlaw. That being said, Fastcase, the annotations are all computer generated. So you're getting some relevant case hits, but it's not necessarily the benefit of having an editor. Fastcase also has an authority check, which allows you to search for other cases citing to your case, but this is also computer generated, and it's not nearly as reliable as checking validity in a key site or a Shepard's, and Fastcase will even tell you that. But if you're just doing some basic initial case or statutory research, Fastcase is a great free resource. Another free resource for initial case searching or statutory or regulatory searching is Google Scholar. And I think this is a database that may be new to some of you, but it's not that new if you've been online and heard of Google. It works the same way as Google, only it's pulling for more scholarly materials. And it has a large database of legal materials, including opinions. So if you go to scholar.google.com, you'll have the option to click articles, which is probably the default, or legal documents. And if you select legal documents, it gives you the option to pick which court you want to search in. Because it's Google and it knows everything, it realizes we're in Virginia and has defaulted to Virginia courts, and I'm leaving it there. But you could play around with that. So Google Scholar works quite well when fishing for cases through basic keyword searches or looking at a case when you already have a citation. Similar to FastCase. If you already have a case citation, throw it into Google Scholar. It's going to pull it up for you. And remember, opinions are the same no matter where you're pulling it from. It doesn't matter if the text is coming from Google Scholar or FastCase or Lexis or Westlaw. What the judges wrote remains the same. The search function on this is a Google search function, and Google's pretty good at pulling up relevant cases to the top of a list. You also have some advanced search features, but not as sophisticated as you can get probably with Lexis, Westlaw, or even the FastCase Boolean searching. So I've pulled up a search in Google Scholar where I just did a very simple modifying child support in Virginia cases, and here's the result list that I get. You'll notice that it has a citing to a cited by 46 listed on that first case. This is also entirely computer-generated list of sources citing of cases that cite to the case you've pulled up, but it's a starting point. So if you're just getting started with research, want a place to play around a little bit for free, kind of see what's out there, absolutely this will work for your purposes. Google also allows easy access to the online Virginia code provided by the General Assembly. Just doing a flat-out Google search for Virginia code, the first hit is going to take you there. And it also allows you to search for the Virginia Administrative Code or Virginia Register, which are not available in FastCase. FastCase actually will just point you to the same thing Google takes you to. So Google Scholar and FastCase are great places to start for free research.
So knowing about the existence of these free resources is great, and it brings us to theme 4B, which is once you've been able to get some background, once you've been able to do some work for free without incurring any kind of charges, then go ahead and use Westlaw and Lexis, but use them for their strengths. There are certain things that these databases are really good for. There are certain things that it is worth paying the money for. And now is the time to start doing that. Once you've been able to do a little bit of initial work to get yourself going, then turn to Westlaw and Lexis so you can take advantage of their sophisticated tools that you're not necessarily going to find elsewhere. So for example, the case digesting or key number systems that you've got in both Westlaw and Lexis are great tools to use for legal research. So what we have here is the same case on modifying child support that Leslie had been looking at. She was able to pull this up in FastCase. So again, FastCase is free to Virginia bar members. So you do some initial keyword searching. You find one good case that is on the right topic. Then you can go and switch over to Westlaw Next, for example. Pull up that same case there. You haven't spent any time searching for it in Westlaw. You already knew about it from your work in FastCase. You can pull it up here, but now you can take advantage of Westlaw's sophisticated digesting tools, more specifically their key number system. And here, for example, you'll see in the headnotes to this particular case, there is a headnote here on contracts relating to support. And so let's say, for example, that is the issue that you really care about, whether ex-spouses can contract between one another about child support outside of the court. Let's say that's your issue. It is very easy in Westlaw Next to be able to identify that find an appropriate headnote, and then click on that headnote, and the next screen you'll see is a list of all of the cases or all of the headnotes from those cases relating to that specific topic. So these are going to be all of the cases that the Westlaw editors have identified as being related in Virginia to contracts related to support. So this is a great tool to use. The key number or digesting tool, you can do a similar thing in Lexis Advance. Doesn't work quite as well, but you can do the same type of searching over there. This is really nice because once you've found one or two good cases through your free research, you can then hop over to the paid databases and very easily pull up a whole list of cases that they have already identified for you as being related to a particular topic. Next, Westlaw and Lexis are great in that they allow for more powerful and targeted searching than you might be able to get in some of the free resources. So Google Scholar, we know that's going to be good for basic keyword searching, your Google type searching, which is fine. As Leslie pointed out, Fastcase allows for more sophisticated Boolean searching using proximity connectors, root expanders, that kind of stuff. That's really going to be no different between Fastcase and Westlaw and Lexis. But what they do allow for is more precise searching by using their advanced search screens. So you'll see here, if I'm looking at the Westlaw's Virginia State Cases database, I can click on the advanced search screen here, and now here I can do what they call field searching. And this can be really nice when you need to be a bit more precise in what you're searching for. So let's say your general keyword searching is still pulling up far too many cases. You can then go to Westlaw's fields, or in Lexis they would call these segments, and there they break the documents down by section. And so, for example, you could do your searching in just a specific section or field within the case. And the one that we often like to use in Westlaw for case searching is the synopsis or digest fields. Those allow you to search just the brief case summary that the Westlaw editors provide for you at the top of a case, or the digest field allows you to search just the headnotes. And so you know if you're plugging keywords into either of those fields and you get a hit, if that wording is in the synopsis or in the headnotes, you know that the case is probably going to have something significant to say about that particular wording. Lexis has similar features, especially Lexis.com. It's my understanding that Lexis Advance will be rolling out additional segments. They do have some segment searching allowed in Lexis Advance. It's not quite as good as what you're getting in Westlaw Next, but I believe they're going to continue to roll out additional segment searching in the future. But in both Westlaw Next and Lexis Advance, you're able to take advantage of breaking documents into pieces and doing your searching there. Third is that Westlaw and Lexis provide you easy access to unpublished opinions, and several judges did specifically say in their responses to the survey that they certainly read unpublished opinions on the topic. Each court has its own rules as to whether or not you can cite to unpublished opinions and what you're supposed to indicate when you do cite to them. Regardless of that, though, they are very useful research tools. They're a great place for getting background on a specific topic, even if you're not necessarily going to cite to them. And Westlaw and Lexis allow you easy access to them that you're not necessarily going to get through a database like Google Scholar or Fastcase. Fourth, the annotated codes and specifically the annotations that you're going to get in Westlaw and Lexis are just better than you're going to get elsewhere. That's because they've got people actually putting together these annotations for you. So just as an example, and this is what Leslie pointed out as well, with Fastcase, they do have annotations. So if you're looking at the Virginia Code here, looking at that same Virginia Code section that Leslie was looking at earlier, here they do have annotations. These are computer generated, however. So for example, if we look down at the fifth entry here, Roberts v. Roberts case, this case does happen to use that Virginia Code section, it does cite to section 20-107.2, but that's about it. It is actually citing to that section. It lists those numbers basically in a citation to another case and really doesn't have much at all, if anything, to say about that code section. And so, yes, it is correct that those numbers are in that case, but really that's not an accurate annotation because the case really has nothing to say about that statute. On the other hand, if you look at Westlaw or Lexis's annotations to the Virginia Code, they're going to be a lot more relevant. On this screen, we have an example in Lexis Advanced, the same code section, 20-107.2 from the Virginia Code, but here you've got people power. You have actual editors looking at these cases and making sure that they are relevant to the specific code section, and the way they organize their annotations are much more useful. And so it's not just a list of every case that cites to section 20-107.2. Instead, you can see here in Lexis Advanced, they've got them organized, and they have an entire section of annotations, as you see at the bottom here, just on support. So you could go right to those annotations and find those cases that the Lexis editors have identified as relevant to their analysis of this section on the topic of child support. And so the annotations are just better in Westlaw and Lexis. No one, as of yet, has been able to duplicate what they do simply because they're big companies who can hire a lot of people to do this work for them. Fifth, KeyCite, which is Westlaw's system of identifying citing references to cases or statute, and Shepard's, which is Lexis's system, Shepardizing, are better than any other citators you're going to get in any other databases. So, as Leslie pointed out, going back to our same case on modifying child support, FastCase does have something they call authority check, but they themselves will say, if you look at the help screen on authority check, that it is computer generated and it is not meant to replace a more authoritative citator. And the authoritative citators they mean are what you're going to find in Westlaw. So the citing references powered by KeyCite in Westlaw and the Shepardizing that you're going to get in Lexis are better than anything you're going to get elsewhere. And again, that's because they have hundreds of editors working on this stuff, and they can make sure that their citators are more accurate and more relevant than other places. And finally, you're going to get better searching of Virginia regulations in both Westlaw and Lexis. Leslie pointed out you can get to Virginia regulations through the internet, through Google, straight from the Virginia General Assembly. FastCase will have listings of regulations that will then just pass you on through to the Virginia General Assembly site of the Virginia Administrative Code. But if you want to be able to do the sophisticated keyword searching of these regulations, it's not so easy to do that from the administrative code as available from the General Assembly. So you're better off doing that in Westlaw and Lexis. So what you want to do is sophisticated keyword searching of Virginia regulations. That's a feature that Westlaw and Lexis allow that you're not necessarily going to find elsewhere. So what we have, and this is part of the course materials, I believe, that were distributed as part of this CLE. What we have here is just a chart that Leslie and I came up with using our own green smiley face symbols and stop symbols and yellow triangles to show caution. And so basically this just goes through a series on the left of different types of research you might do, and then at the top there's 4 different resources you could use: Westlaw Next, Lexis Advanced, FastCase, and Google or Google Scholar. So obviously you've got 2 subscription sources there, and then 2 of the free sources that Leslie went over. And we just kind of go through each and identify which databases will actually let you do this kind of research, which ones might let you do it, but you want to exercise caution. The main thing to take away from this screen is you can see how many green smiley faces we have listed under both FastCase and Google Scholar. So there's quite a bit of research you can do for free, either using what the state bar is providing you for free through FastCase or using Google Scholar, which is free to everybody. There is a fair amount of research you can do before you have to start incurring any charges through Westlaw or Lexis. And that brings us to our conclusion. So what do you want to remember out of this? What kind of takeaway points do we have for you? The first one is make sure you have a plan before jumping in. We are a culture where we just go straight to searching. Google wants you to search. Google is coming out with glasses so you can search stuff without even thinking about it. As soon as you see something, you can search it instantly. That's kind of the culture we are a part of. But what we want to encourage you to do is think first before you jump in. Your research is going to be much more effective. We both spend our entire day, every day, doing legal research. We certainly do not write out detailed research plans before we do our research. We're like you. We want to kind of get into our research as quickly as we can. But we certainly do spend some time thinking about, okay, what is my approach going to be? What are the best resources for this particular question? How might I want to construct this search to get the best results? And we promise you, if you take a little bit of time to do that, your research is going to be much more effective. It's not going to take you as long to kind of stumble along and find things if you put a little time in advance thinking about how to do it. Analysis. Remember, this was a big one with the judges. They don't want you just to be good searchers and finders. Anybody can do that. They want you to be lawyers. And so this means being able to analyze your results, so not spending all of your time just searching in online databases, but doing your searching and then taking a time to actually read what you found, put it all together coherently so you can describe what the body of law is in a particular area, and then spend some time thinking about how that law applies to your client and doing that analysis. So research, yes, is about knowing how to search for stuff, but it is also about knowing what to do with the search results you have found. So being able to analyze what you have found. Remember, there's a danger in keyword searching. Don't take things out of context. It is great that we can plug in keywords, sophisticated keyword searching, and find great quotes fairly easily through all the cases in Virginia. But remember, those quotes are made in context. So don't just pull a good quote out without looking at the big picture. Make sure you know the context. Why did the judges write that particular language? What was going on in that case that caused them to come to that decision? And that is what the judges want to see from you. Not just a bunch of good quotes. Those are good. Those are helpful. Those are great to highlight your points. But make sure you are not getting that keyword tunnel vision and you're looking at the big picture. You're understanding context. Fourth, don't reinvent the wheel. I often tell my advanced legal research class that's the number one rule of legal research. Don't reinvent the wheel. It is very likely that if you're looking into an issue, someone may have already done so, and they may be an expert in that area. So turn to secondary sources to get your research started. Don't just feel like you've got to jump right into Westlaw and Lexis and start doing your own searches. Someone may be able to guide you there. And that stuff may be free because you may have already bought these books and have them sitting in your office. Or you can go talk to one of your colleagues who may be an expert in this area. But use secondary sources to your advantage. You don't have to start anew with your own searches. Let an expert guide you. And there are plenty of secondary sources for Virginia that you can use to do so. Finally, use resources, including the online databases, for their strengths. So there are certain things that Westlaw and Lexis are better than anything else. There's certain things that it is worth paying them for. Use them for those things, but don't just default to using them. Don't just use Westlaw or Lexis because you're used to them and they're there. There's plenty of stuff you can do outside the bounds of Westlaw and Lexis, but then know what are the strengths of your different resources. There are certain things that I can do really well in Westlaw and Lexis. I'm going to turn to them for that. There are certain things that a print secondary source might be my best resource. So know what the strengths of your resources are and use them to your advantage. And that is it. Thank you very much.